Okay, well, it gives me great pleasure to kick off the first of our Singapore Symposia in Legal Theory for this year. And I'm just delighted to present Dr. Arie Rosen. Arie Rosen is a senior lecturer at the University of Auckland, Faculty of Law, and a co-director of the New Zealand Centre for Legal Theory. His interests span general jurisprudence, constitutional theory, and the philosophy of private law. His published works covers methodological questions in jurisprudence, the theory of authority, statutory interpretation, and relations between the concept and the nature of law. His current research on democracy and contract law is funded by a Marsden grant awarded by the Royal Society of New Zealand. Now, the subject of today's talk is economic liberty and the fragmentation of contract law, which I think is an excellent topic. One of my colleagues, who I shall not name, says the Singapore Symposium in Legal Theory always works best when somebody brings an interesting philosophical perspective to bear on something that really has to do with the law. And this paper absolutely does that. So without further ado, we will follow our normal practice. So Arie will speak to us for about 45 minutes. We will clap, and then we'll turn off the video. And then Arie and I have agreed that I'll speak for about 2 or 3 minutes, just raising some issues, mostly of clarification, and then I will open the floor to your questions. Over to you, Arie.
Thank you very much. Thank you, everybody, for coming. Thank you for inviting me. It's a pleasure to be here. So the topic that I've shared with you today, is part of a book project on democracy and contract law that is generously funded by the Marsden Fund and the Royal Society of New Zealand. And in this paper, of which you've read a very, very early draft, I'm focusing on the relationship between two questions, or two theoretical questions. One in political philosophy and political theory, and that's the place of economic liberty, and its privileged place in liberal democracies. And the second is the fragmentation of contract law. And I just want to start by kind of explaining what I mean by these two terms, and then move on to the discussion. By economic liberty, I mean loosely the set of liberties, rights, powers, immunities that are traditionally thought of being necessary for actors to be meaningful economic actors in a free market. And when political theorists usually talk about economic liberty, they tend to get fixated on property rights and strong property rights, and particularly, and rightly so, private property rights in the means of production. But an important aspect of economic liberty has to do with freedom of contract and the ability to do things with your entitlement and transport them. Freedom of contract and economic liberty more generally are pose a controversial question in contemporary legal theory, where the question normally revolves around the way we define the scope of these different economic liberties, and how strongly we are willing to protect them when they clash with other normative commitments that we have. And it's an important question in legal theory because it's kind of a watershed question, because it really distinguishes different strands within liberal theory: libertarians, classical liberals, neoliberals on one side of this debate, and high liberals or libertarian liberals on the other side, kind of allocating different responsibility, delineating the scope of these liberties differently, and insisting on different commitments to the protection of these liberties. By fragmentation of contract law, I mean nothing more and nothing less than the plurality of legal regimes that regulate contracts in our law. And this plurality of regimes that has a dynamic aspect to it, hence the insisting on fragmentation, is closely related to the question of economic liberty, because different contractual regimes show different commitment to economic liberty and have different levels of state prescription, which is the inverse of what economic liberty is in the realm of contract law, that is the freedom of the parties to determine the terms of their own contracts themselves. Now, to the extent that these two questions are obviously connected to each other, I think that they suggest a certain priority, and the priority seems to be not unjustifiably a priority to the political question and the normative question. So what is the right level of commitment to economic liberty that our law should show? And once we have that sorted, we can go back to contract laws and evaluate, see if it meets the correct standard, and also tell us what we need to do in order to get it to the right place, to the right level of economic liberty. But actually the argument of the paper goes the other direction. It starts from contract law and exploring the structure of the fragmentation of contract law, this plurality of regimes, and suggests that in it we'll find something about the way our law is actually attached to economic liberty in practice, and also maybe the normative way forward into how to think about economic liberty in a slightly different way, so offer a slight correction or a different perspective to the debate than the mainstream perspective. So what I'll do in the next half an hour or so is talk a little bit about contract law theory and how it deals and should deal with the challenge of fragmentation. And that would be, I think, most of the presentation, I think. And then say something about the place of economic liberty in liberal political theory in light of this analysis, kind of how this analysis can inform our political theory. Good? Yeah. Okay. The fragmentation of contract law poses a challenge to contract law theory, just in the sense that it's there and it requires us to address it. And kind of going through the literature on this, I think we can identify 3 different strategies that theorists take when they think about fragmentation. One strategy is just ignoring it, right? So there's a lot of contract law theory, there's a lot of very good contract law theory, very good private law theory more generally, that simply defines its subject matter narrowly. It says, I am a theory of general contract law, private law in contract law, and I'm just not worried about all these other policy-oriented regulatory regimes. They're not really private law, they're not really contract law, whatever. And that's fine. This can be very insightful and very good, and I use a lot of it in the paper. But they are missing the challenge, right? So there are a lot of people who think that by focusing just on general contract law and just on private law, you're missing an important part of the picture of modern contract law. And there are a lot of good people who think that the whole range of contractual regimes deserves some theoretical attention. And often these people, when they offer a theory of this field of contract law, this broader field of contract law, take another strategy, another route, and that is to assimilate these different regimes, to try to find common principles, common theory of the entirety of the field. And so, for example, they can say, well, general contract law is all about individual freedom and more broadly individual autonomy, and all these other regimes, tenancy, employment, consumer credit, etc., that seem to be regulative and policy-oriented and do all these other things, are actually also about individual freedom and autonomy if we just properly understand them in a deep way. Or the other way around, they can say, well, all these other regimes are obviously regulatory regimes, they're policy-oriented, etc. And guess what? So is general contract law, just like this other field. It seems to be about something else, but actually it isn't. And And the problem with that analysis, or which can also, it's not really criticism, these are different perspectives on the questions, but I think that the shortcoming with that sort of interpretation is where it becomes tenuous, and that's where it says things like, it seems to be one thing, but it's actually a different thing. And I think that if you look at the actual principles that are articulated in court decision, legislation, etc., as being the animating principles of these different fields, and which are in practice the animating principles of these different fields, you actually see divergence. You see that some regimes are about regulation and attaining policy goals and doing that sort of thing. And general contract law does seem to be different in being different, in being about, well, individual autonomy. We'll get to that, exactly what it is about. But it seems to have a different logic. Now, people who are attentive to that and say we can't assimilate often go for a third strategy, and often is the wrong word because there are not many of them. But when they do, they tend to say something that I, take a strategy that I call here dethroning. They say, you know what, these different regimes are different from each other. They're different from each other in the principles that animate them, and that's fine because they regulate different types of transactions, and different types of transactions should be regulated differently. Why is this dethroning? Because in the process of doing that, they're reducing the level of majesty of general contract law. They say, general contract law is what we call a law that actually regulates a subset of contracts. So we have employment law that regulates employment contracts, consumer credit law that is that, and general contract law, which we call general contract law, actually only applies to a subset of transactions, namely commercial transactions between businesses. So these are the three strategies we find in the literature, and I want to particularly kind of attack the last of these, both because it's closest to my own intuitions, but also because my point is the opposite. Everything that I'm going to say in the paper is about how special general contract law is, how magisterial, how it's special as general contract law. So I want to do two things. I first want to just get out of the way clear ways in which general contract law is special and deserves to be recognized as special by our theory, and then say something more say deeper about the analytical structure underlying its magisterial place. The obvious way in which general contract law is special has to do with the fact that it is a general law. And as general law, it has a default position, it has a special analytical position, in the sense that it is the regime that would have been regulating all transactions unless they were explicitly derogated from it. Why is that important? Well, first of all, it's important to take into account when we do theory, but it has practical significance. Right? General contract law continues to apply as a lex generalis in the realms of special contracts, as long as the norms of special contractual regimes don't derogate from it. That's something that we have to contend with. But perhaps more fundamentally, being this default position, being general law, the emergence of new contractual regimes and the continuous operation of contractual regimes happens against the vector of this general contract law, which sets kind of, we can call it the imaginary, the ideology of what a contract is, and it kind of sets the scene for the entire operation of the field, even though it's derogated from by the special contractual regimes. If I said something that sounds contentious, I didn't mean to. I think this is all kind of non-controversial. But I think it's enough to tell the dethroning people, hey, wait a minute, general contact law is not just another option on the menu, it has some sort of special analytical position in the field. If we look closer at this analytical position, we find that general contact law is special in the modalities of abstraction that it employs in, on the one hand, describing the contractual relationship and the situation that gives rise to a contractual relationship. And that's the second dimension of abstraction, its particular mode of abstraction of the person. These two things are distinct from each other, so I'm going to talk about them separately. By abstraction of description, I mean the following. So every legal description of a situation, every legal analysis offers some sort of abstraction from a factual situation. We take a factual situation and we eliminate certain legally irrelevant factors from the description, and we get a legal description of the contractual relationship. You know, some factual situation gives rise to consumer credit contracts or employment contracts. And the thing is, if we continue to abstract from that description and we eliminate from our description the subject matter of the contract and the identity of the parties, what we're left with is mere contract. It's just contract without these special designators. And that's the level in which general contract law operates. General contract law operates at the level of mere contract. And again, I don't think that I don't mean to say anything controversial by this. This is just what it means to be general contract law. This is just saying generality by other means is to talk about this abstraction. It's the same thing. But I think it is important because I think it gives a good analytical framework to talk about fragmentation. Right? Fragmentation in contract law is just an exercise of reducing the level of abstraction of the contractual regulation from the level of mere contract to some more specific sphere. And there can be great reasons to do that. Some contracts give rise to special autonomy interests of the parties. Some contracts give rise to, are more susceptible to market failures of different sorts. Some contracts are very significant in terms of societal distribution, either between the parties or in greater society. And all of these things justify regulating them separately, giving a priority or giving some weight to the normative considerations that only appear once you identify the context, the subject matter of the transaction, and the identity of the party. The second element of abstraction is connected to this, but is different, and that goes to the abstraction of the person that is assumed to be the subject of contract law. And here, again, we can have in mind a very embedded person, a person embedded politically, societally, economically, familially, tribally, relationally, etc., etc. Or we can have a further abstraction of this person that goes all the way of shedding all of these embedded contexts and leaves us with the partial individualistic person, the classical person of classical liberalism, the individualistic pursuer of individualistic ends. Yeah. Why is this important? In what sense do contractual regimes assume different people? Because it's meaningful, because assuming a different abstraction of the person make us see different sets of reasons as applicable to them. If we think about a partial person, abstracted from all of her communal situatedness, then we think of the reasons that apply to her from what Nagel calls her personal standpoint, as a partial individualistic pursuer of ends, of her own interests. But if we see the person as more embedded as a member of a polity, of society, of economical structure, etc., there are all sorts of impersonal reasons that apply to them due to their membership. We sort of think about them being a member and not special, the reasons that apply to them as non-special members, just like they apply to everybody else, hence the impersonal standpoint. Is that clear? Oh. So, how are the two modes of abstraction connected? Are they connected? Yes and no. They're connected, yes, no. They are connected but not identical. In the following way. You can have general contact law operating at the highest level of abstraction of the description of the situation, regulating mere contacts, with a very embedded abstraction of the person. Maybe communist contract law is like that. It operates at the level of general contract law, regulates all contracts as mere contracts, but it employs a very embedded abstraction of the person as a member of a political community, as a member of a particular party. And therefore, it can read impersonal duties into the contract through this membership. So communist contract law says things like, the objects of the state are the objects of every contract, something like that. That's one. Okay, so they're different from each other. They're not the same thing. But they're connected in the following way. Once we reduce the level of abstraction of description of the situation, and we say these subset of contacts with their particular characteristics deserve special regulation, the identity of the parties to these contacts also becomes more concrete and less abstract. So suddenly the parties emerge as either people who are, whose autonomy is vulnerable or are threats to personal autonomy, as people who have certain biases or people who exploit certain biases, people who are on a certain position on the distributive scheme of wealth and income in society, and people who are different, etc. And in that respect, they are connected. And this connection explains why we see a greater level of regulation in special contracts. Right? Because special contracts reduce the level of abstraction of description and therefore employ a more embedded abstraction of the person, through which impersonal duties as members of economic structures, as members of society, as members of relations, as members of a political community are funneled into the relationship. And we read them into the contract and we prescribe them through these special contractual relations. Is that okay? Okay. So, in a minute I'll go to the last part of the presentation about economic liberal theory. But I just want to note how even what I said so far should shift just a little bit, or shift it, highlight a different aspect of the debate surrounding economic liberty in modern liberal democracy. If we look at the way that our actual contract law actually privileges economic liberty, we see that unlike what the debate says, it is not structurally committed either to a particular definition of economic liberty or freedom of contact, the delineation of this in a particular way, or to a particular level of protection of economic liberty, the quantity of economic liberty in society. On the contrary, it's modular. It allows for deviation. It allows for the creation of more regulation through the creation of special contractual regimes, or their elimination, potentially. But that does not mean that it has absolutely no structural commitment to economic liberty. It has structural commitment to economic liberty in the way that it privileges general contract law, which is itself committed to a high level of generality and abstraction of the person, and for which is committed to a high level of economic liberty and a low level of state decision. I think that's important. It's not the point of the paper, but I think it's important. The question is whether anything can be said about why this is a good idea, why this would be justifiable. And that's the last bit of the presentation. How would we justify this presumption in favor of economic liberty that is built into the structure of contract law through the privileged place of general contract law, which privileges economic liberty? How would we justify it? One way we might want to justify it is taking the liberal out, the classical liberal out, of talking about a presumption in favor of liberty. And I think that doesn't work. So I'm going to suggest another route, a different presumption, also inspired by kind of private law theory and contract law theory, and that is the presumption in favor of the abstract partial person. So what I want to do is, that looks like a lot, but just talk a little bit about why freedom of contact is not actually freedom and why economic liberty is not actually liberty. And therefore why the presumption in favor of liberty can't justify a presumption in their favor. Then kind of recap why a certain abstraction of the person as a partial person yields also economic liberty, how it's a different route to get to economic liberty, and then say why a presumption in favor of it is justified. Okay, so is freedom of contact a type of freedom? Is economic liberty a type of liberty? Well, no. Why isn't it? Because if we try to think about it as individual positive liberty, we run into all sorts of difficulties. So when we think about contacts, freedom of contact, they are obviously connected to positive liberty in the sense that they allow people to do things together. It's a facilitative mechanism. But it's not at all clear that it facilitates individual positive liberty. Yeah? And that is because no party to a contract can determine the terms of their own contract. The terms of contracts are determined either by the market or whatever sphere of power relations that the parties bargain in, or through the political system, through governmental description, through state perception. And the question which route better serves the positive liberty of individuals depends on the relative position in these two systems. So, and there can be different contingencies here. In a very dubious, unequal, centralized political system and a decentralized market with low disparities in bargaining power, it might be true that leaving more decisions to the market would allow more individuals more control over the terms of the contract. But if we have a very centralized market with great inequalities between the parties in terms of bargaining power, and a functioning political system that is pretty much egalitarian, then actually it might be that people would get more say about the terms of their contract through the political system. And that just means that, individual positive liberty and freedom of contract might come together, but they can also come apart. And that means that it's not a type, freedom of contract, economic liberty, it's not a type of positive. Is freedom of contract a type of individual negative liberty? Well, depends who you ask. Under certain assumptions, under libertarian assumptions, and a particular understanding of what contracts are, namely understanding of the moment of contracting is transferring a pre-statist natural entitlement to another person, restriction of freedom of contract actually means that the state refuses to protect an actual entitlement that people have as an aspect of the individual. So in this framework, which we should reject, it does make sense. We can think of freedom of contract as an aspect of negative liberty, individual negative liberty. But once we relax our libertarian assumptions, as we should, for good reasons, or we employ a different understanding of what contract is, a question on which I'm agnostic, this structure disappears. If we lose the libertarian assumption, then the contractual right emerges as something that is not pre-statist, not natural, but is actually delineated, prescribed by law. And the way that it is delineated, since it's not natural or pre-statist, is subject to the same normative considerations that all law is subject to. And that makes it not part of individual negative liberty. Even if you are a libertarian and you're not a transfer theorist, it also goes away. Because if you're not a transfer theorist and you think of the realm of contract law as the realm of promises and the enforcement of promises, then freedom of contract is just individuals calling upon the state to enforce their promises. And again, not natural entitlement that they have. And that again takes us away from the sphere of negative liberty to the statist sphere. So the point of this bifurcated account is to say there's simply no alignment between at least this aspect of economic liberty, that is freedom of contract, and individual liberty. And I think this disjunction is at the heart of the hostility of high liberals and egalitarian liberals towards economic liberty, towards freedom of contract in the second half of the 20th century. Because these arguments are kind of, they're not original, right? These are the arguments of the New Dealers and the people before the New Deal that told us that freedom of contract is not sacred. And this, in the second half of the 20th century, this was kind of brought home by Rawls and Nagel and Dworkin and others, and that said, well, if they're not special in liberal theory, they don't deserve a privileged place like others. I just want to note that the route that I'm suggesting to economic liberty is of a different kind. If we think about the abstraction of the person and the abstraction of the partial person, then freedom of contract is almost a byproduct of a certain way of seeing. If we abstract individuals in this maximal way, almost maximal way, with a high level of partiality, then we don't attribute to them any ends, either based on their embeddedness or based on their interest or based on their ends, because we don't know them, we abstract from them. And since we can never impose ends on individuals and treat them just as means in our law, what we get is just a law that is appropriate for the regulation of the interaction between free, abstract, partial individuals. And I think, again, I think this is a different route to economic liberty that is not premised on the false assumptions about freedom of contract and economic liberty being a natural designator of liberty in the way that libertarians do. And I think is respectable. And the last slide is about why it's respectable and why it deserves a presumption in its favor. In order to understand what justifies a presumption, we have to properly understand what is the relationship between the partial person and the more embedded person, between the personal standpoint and the impersonal standpoint. And the first thing that we know is that the impersonal standpoint is very demanding. Can be very demanding. And this is, it's demanding in the following way. It's demanding in the sense that after all of our impersonal reasons and impersonal duties are funneled into the relationship, it's not clear how much space we've got left for the partial pursuit of individualistic ends. And this is kind of this is why I rely on Nagel, because I think he gets this point very nicely. This potential threat to the partial person, to the personal standpoint, to permissible partiality, is problematic in two ways. One way is that it seems to be going against our human nature, at least right now. We have individualistic ends. It's part of our psychology. It's part of our economy. It's part of who we are. And this is kind of an anti-Marxist intuition that says we are not interested in utopian projects to reform human nature. That's the problem with Marxist utopians. The second thing is that I think, and this does go to a core tenet of the liberal tradition, that's not to a core tenet of the liberal tradition. We think that this partiality, this personal standpoint, is valuable. We don't want to see a world in which individuals just have impersonal duties. We think that it's important to have a world in which individuals are also the pursuers of individualistic ends. So this is the first point. The second point goes to the relationship between the impersonal and personal standpoint, between this very demanding impersonal standpoint and the personal standpoint. And that's the incommensurability. Right? Liberal theory doesn't know what to tell us about the correct balance between the impersonal and personal standpoint. It can tell us that there ought to be a balance, that the personal standpoint, that the partial individual cannot be eliminated, that we want to see it somehow. But it doesn't know how exactly to go over that. And all of this comes to a systemic vulnerability of the personal standpoint of the partial person to the ever-increasing demands of embeddedness and impersonal reasons. And given that vulnerability, a procedural solution in the form of a presumption makes very good sense. Right? Presumption is a mechanism that we use when there's a vulnerable value, vulnerable commitment that we know we might have to compromise from time to time. But we don't want to compromise it in an overly promiscuous way. Huh? And that's exactly what we have. We have a structure of contact law, of structural fragmentation, that tells us the presumptive regime for regulating contractual relationships is a regime that is committed to the personal standpoint, to the permissibility of partiality, and to the abstraction of the partial person. If you have a good reason to do something else, to compromise this commitment, you can do so. But only for a reason, only explicitly, only actively, only as a lex generalis, a lex specialis derogating from a lex generalis. I repeat that. Only as a lex specialis derogating from a lex generalis. So, apart from illustrating for us what actual commitment modern contract law has to economic liberty, not to the scope of economic liberty, not to the strength of its protection, but as a presumption, we can also say that contract law theory and private law theory guides us into the right, in the right direction of why we value this presumption. We value this presumption because we value partiality, we value the personal standpoint, and this we don't value only it, we value other things as well, but we value it, and because it's systemically and structurally vulnerable, we give it this default position. We give it presumption in its favor. And that's the end of my presentation. And I look forward to your questions.